Time has expired, and we appreciate the argument.
Thank you
so much. All right, we'll call our next case Hill versus Southeast Restoration.
Good morning.
Good morning, sir.
I'm Evan Self.
Hold on just a second. Let opposing counsel get himself comfortable there, and we'll get started. Would you like to reserve some time?
I would, Your Honor. I would like to reserve 5 minutes for rebuttal. Evan Self on behalf of Robert Hill and Christopher DERANEY in this appeal from a motion for summary judgment. The trial court, the underlying cause of action was related to damage caused to Mr. Hill and Mr. DERANEY's condominiums, which was located at the Leaky Atrium condominiums in Ormond Beach. The damage was caused by the defendant, who was a restoration contractor on an adjacent condominium. This was all occurred in August of 2004. During that season of hurricanes that we had that year. The allegations in the complaint were that the defendants negligently took care of the construction site such that flying debris then struck the plaintiff's condominium, causing it to suffer increased water damage as a result of the breakage from the flying debris caused by the hurricane. Lawsuit was ultimately filed January 22nd of 2007, and the defendants served a summary judgment on December the 1st, which was filed on December the 5th of 2008, and a hearing was held before the trial court on December 22nd of 2008. The basis of the motion for summary judgment was the plaintiff's alleged lack of standing. We believe that the defendants presented to the court, in essence, a red herring issue regarding the standing, in that they presented as the basis for the factual basis for that answers to requests for admissions in which the plaintiffs answered that they were not the owners of the condominiums at the time of the hurricane. Clearly, the record evidence suggested that Mr. Hill was the owner of the condominium at the time of bringing the lawsuit, and that Mr. DERANEY subsequently, during the pendency of the lawsuit, became the fee simple owner. But
let's kind of address them separately. I mean, you concede that neither Hill or DERANEY had legal title. If you look at the deeds at the time that the loss allegedly occurred, back in 2004.
Correct.
Neither Hill or DERANEY had legal title. Is that correct?
That is correct, although they both were residents of the...
I understand, but you're not claiming that, something came through the window and damaged our personal property. Yours was, the claims that would be brought by the owner of the unit.
Correct.
All right.
Well, although there's
let's talk about them separately.
Okay.
Because they do seem to be, let's talk about Hill first.
Okay.
That was held in the Grace Hill, legal title was in the Grace Hill Trust.
Correct. The Grace T. Hill Properties Limited, which there was a general partner of GTH Properties Ltd., GTH Holding Incorporated.
Right, I understand, but it all ends up, it's, in these various entities, it's in the Grace Hill Trust.
Correct, Your Honor.
And Mrs. Hill dies in January of 2003, which under the trust triggers certain things. And basically, the trust is divided into two. Whatever's in the trust, which included the condo, gets divided into, the pie is sliced in half. One half goes into a trust for Mr. Hill's benefit, of which his sister is the trustee. And one half goes into a trust for the sister's benefit, of which Mr. Hill's the trustee. Right?
Yes.
We don't know, for example, we don't know where that property went. I mean, we know eventually it goes to Mr. Hill, but certainly at the time, we don't know what was going on with it. But I guess the real question is why at the very least aren't the real parties in interest? I mean, by that time, the successor trustees should have been Mr. Hill and his sister.
I think at the time...
Why didn't you just bring the lawsuit that way?
I'm the appellate counsel, Your Honor. I wasn't the trial counsel. So my understanding is that the trial counsel bringing the claim that these issues did not arise until December of 2007 when the depositions of the plaintiffs were taken, and some of these issues came to light during the actual pendency of how these properties were actually being held in fee simple.
Did trial counsel ever move to amend the complaint to say, okay, Mr. Hill individually may not be the proper party, but Mr. Hill and his sister as successor trustees are the proper parties, and there's no prejudice to letting us just substitute?
He did not do that until the day of the hearing on the motion for summary judgment, and on that day he clearly states in that hearing that if we need to amend the pleadings to name the proper parties, that we can do that. He suggests that as a suggestion to the trial court, rather than granting the motion for summary judgment, that the court, I'm presuming that to be an ora tennis motion to amend the complaint to name these proper technical parties, although I really believe that pursuant to Rule 1.210, that Mr. Hill and Mr. DERANEY, both as trustees and beneficiaries of the trusts under which they were living in those properties, can actually bring them in their own name. I think the rule of civil procedure suggests that beneficiaries, trustees, personal representatives can all bring these can bring any cause of action on behalf of the trust, estate, or otherwise in their own name. And I'll quote for the court, every action may be prosecuted in the name of the real party in interest, but a personal representative, administrator, guardian, trustee of an express trust, a party with whom or in whom whose name a contract has been made for the benefit of another, or party expressly authorized by statute, may sue in that person's own name without joining the party for whose benefit the action is brought.
But I mean, arguably, when Mrs. Hill, the mother, passes away,
correct,
and there's nothing you can't tell from just looking at the trust whether the condo was going to go to Mr. Hill, go into his trust, or go into sister's trust. So, for example, if it had gone into sister's trust, Mr. Hill wouldn't have any. He wouldn't be the real party in interest.
Well, he was the trustee of that trust, so he could bring lawsuit for the benefit of that property in that trust.
Well, but that would be based the way you would plead the case. You know, I'm the trustee of the so-and-so trust.
I think that if I were handling, and I think in retrospect now, if trial counsel were handling this case and pleading this case from the onset, knowing the knowledge that we have at this point, that in order to clarify and make those issues clear to the trial court, that he would have brought this lawsuit in all of those names of clarifying whether you're bringing it on behalf of a trust, whether or not you're bringing it as a personal representative, or whether or not you're bringing it as the beneficiary of a trust.
Let's talk about DERANEY.
Yes.
The situation under the DERANEY trust looks a bit different. That trust terminated in 2006.
It allegedly terminated. I'm not intimately familiar with all of the details regarding whether or not that trust terminated prior to Ms. DERANEY's death, but allegedly on the face of the document there's an allegation that it is a 10-year trust. Mr. DERANEY was the
he's the sole beneficiary.
Correct.
When the trust terminates, he gets everything that's in it.
Correct. And I think if Mr. DERANEY had to do it again at the time of his mother's death, he would have obviously titled the property in his name. I'm sorry, at the termination of the trust, or at the time of her death, he would have moved for fee simple at that time, but he was clearly a beneficiary of her trust.
Well, wouldn't he have acquired equitable title at that point?
Yes.
And was any of that, I mean, I looked at I didn't read the transcript of the hearing, but I read the papers that were filed, but I didn't see that the argument was ever asserted that, he was, he may not have been the legal title holder, but he was the equitable title holder in his personal right, and he was the legal title owner in his his position as the successor trustee.
Well, I think that Mr. Gonzalez, the trial counsel, raised those issues at the hearing on the motion for summary judgment, but the trial counsel, in essence, stated, and there were some discussions about Mr. Gonzalez had filed a memorandum or brief that had some of the attachments of the trust documents that were included in that, and there was some question about whether the court had received that prior to the hearing on summary judgment, but the court clearly says, regardless of whatever arguments were being promulgated, the court says you can put whatever you want in a brief. If they don't own it, they don't own it. The fact that they're a trustee doesn't give them legal right. The fact that they're a beneficiary doesn't give them legal right. I mean, trustees can live anywhere. Beneficiaries can live anywhere. And then the court goes on to bring an analogy. If General Motors owns it and their board of directors can't bring suit, nor can their shareholders, I mean, those are just collateral manners. The legal interest, if any, if there's a duty owed, it's a duty owed to the owner, probably not even the occupants. I think that's a wrong, and that's an erroneous rendition of what the law and what Rule 1.210 clearly states regarding a party's right, who is an interested party to bring this lawsuit. I think pursuant to the rule and pursuant to the case law, in fact, there's a third DCA case that says, in addition to trustees, beneficiaries, administrators, in that case there's an agent who brings a lawsuit on behalf of an estate. It was an estate that had been closed in Spain, and that's the Wenga case, or Juenga case, Juenga. The third DCA ruled that in that case, pursuant to a letter of agency, that Mr. Jenga can bring the lawsuit in that case against a third party. So to me, on behalf of, he's bringing that lawsuit in his own personal name on behalf of the estate, and it is our position in this case that Mr. Hill and Mr. DERANEY were proper parties. Whether it was specifically clarified in which manner they were bringing the lawsuit, I think made it a little murkier for the trial court, but it is our position and contention that the judge erroneously applied the law in its rendition in granting the motion for summary judgment.
Well, I have a couple of procedural problems with that argument. First of all, there's no doubt that the allegation in the complaint was that they owned the property.
Correct.
And it's clear that they did not own the property.
Well, Mr. Hill owned it prior to the litigation, prior to the commencement.
I'm talking about that they were the ones who, the complaint says that they were the owners who were damaged, that they were the damaged entities, and they weren't. Neither one of those individuals owned that property at the time of the loss.
Right, that they were beneficiaries, and they were residents of it. They were beneficiaries of the facility. They were bringing, they were the ones who were ultimately damaged. They were the successors in interest of the owners because both owners had passed away prior. Let's assume for a second that Mr. and Mrs. or that Mrs.
Well, the
Hill
judge's point simply was. The allegation here is that the owner was damaged. It's clear from the discovery that these guys are not the owners, so they can't succeed on this complaint.
Well, they actually
and Mr. Gonzalez had a year from the time this was discovered to make any correction to the pleadings, to make clear either that they were suing as the real parties in interest or to have somebody else sue as the owners. And that didn't happen. And so then we get to the day of the summary judgment, and what we have is a raft of documents that are offered to the court that he doesn't even have in the file, and which are not accompanied by any kind of affidavit showing authenticity. And the trial court simply says, there's no dispute on this record that these are not the owners, they can't succeed, and summary judgment is proper. I'm having trouble understanding what's wrong with that.
Well, Your Honor, in the answers to discovery, in the answers to interrogatories filed by both Mr. Hill and Mr. DERANEY, both answered those interrogatories, and in those answers talked about how they were the owners. And so I believe at least at a minimum it sets up a conflict of the evidence. If on one hand you have a request for admission saying that they weren't legal titles at the time of I don't think the time of the hurricane is the operative time of when the standing issue needs to be resolved. The operative time is at the commencement of the lawsuit. Are these individuals allowed to, pursuant to the rule, are they interested persons? Do they have the proper standing to bring this lawsuit? And the answer, clearly pursuant to the case law and the rule, would suggest that they are, because they are clearly beneficiaries of the trusts and clearly at the time trustees, or in Mr. Hill's case, the actual owner of the property at the commencement of the lawsuit. So they're allowed to bring that lawsuit as the owners of the property because they're the ones who are damaged now as the owners. I think an analogy could be drawn sufficient to a corporation who may purchase another corporation's assets or liabilities. The subsequent purchaser of that corporation, that successor in interest, is allowed to then commence and bring lawsuits on behalf of agreements that were signed by prior individuals. So in the interrogatory...
Well, that may or may not be true. I mean, if Corporation X suffers a loss to its building and then subsequently sells the building to somebody else, the person who purchases the building isn't necessarily entitled to bring suit for the previous damage.
Again, it depends on the wordings of those documents.
It depends on an awful lot, none of which is in this record.
There are some instances in the answers to interrogatories by both Mr. Hill and Mr. DERANEY that to me creates a conflict of the evidence sufficient enough to deny a motion for summary judgment.
That was never argued by Mr. Gonzalez that there was a conflict.
It wasn't argued by him, but in light of this being a court of error, you're allowed to review this de novo, and I believe that's the argument that should be presented.
Don't errors have to be preserved to be argued on appeal?
They do, Your Honor, and the error, I think the court, regardless, based on its rendition of, you can put whatever, its statement basically that if they're trustees, that doesn't give them legal right, or if they're beneficiaries, that doesn't give them legal right. That's an erroneous statement of the law by the trial court, and as such, the trial court's ruling needs to be reversed.
So if you want to hold some time.
I will, Your Honor. Thank you.
Thank you, sir.
Good morning. I'm Robert O'Quinn from Jacksonville. I was trial counsel for the appellees. The only proper summary judgment evidence before the trial court was the complaint in which Messrs. Hill and DERANEY allege at the time of the storm we owned the condos. That's summary judgment evidence. The only other summary judgment evidence before the court were their admissions to my request for admissions, in which they said they admitted no, at the time of the storm, we didn't own the condos. What's not summary judgment evidence are the exhibits to the memorandum of law Mr. Gonzalez tried to file, but had not filed at the time of the hearing. What's not summary judgment evidence is any factual basis for the arguments Mr. Gonzalez made at the hearing on the summary judgment. The Judge Griffin, as you pointed out, the judge just didn't have any choice. They didn't allege they were successors in interest. They didn't allege that they were beneficiaries. They didn't allege that they were trustees. And Judge Orfinger, as you pointed out, under the Hill Trust, who knows where it went? The poor trial judge didn't know that. He ruled properly on what was in front of him, and he didn't err.
Well, we know that in 2006 it goes to Mr. Hill because there's a quitclaim deed coming out of the trust. So the question, I suppose, is if he didn't have time, if he didn't have standing, when was the lawsuit filed again? Can you refresh my memory?
February of 2007.
So he clearly was the owner at the time of the lawsuit. So if he didn't have standing at the time of the loss, but can he acquire it subsequently by being the successor in interest? And, which admittedly you have to give a very generous reading to every paper in the file. Today seems to be a bad day for motion and pleading practice.
Judge, him having ownership is suspect. And that's for a number of reasons, and you pointed them out. Who knows where it went?
Well, we know where it went because in 06, in February of 06, it's quitclaimed over to him. So
yes,
apparently he and his sister came to some understanding of that.
Maybe, maybe not. That's what I'm saying. You really don't, when I said that you don't know where it went, we don't know where it went after Mrs. Hill died. We don't know whether Mr. Hill and his sister ever sat down and divvied it up and cut it in half. We don't know whether it went to his trust. We don't know whether it went to her trust. If they did divvy it up and it went to his trust, as you pointed out, the sister's the trustee. She's the owner of it. Doesn't it take her to convey it? She didn't convey it. Even in the non-record documents that we have, we don't have anything from her conveying it to anybody. What we have is him as vice president of the holding company, which was the general partner of the LLC that owned the condo. We have Hill as vice president of the holding company executing this deed to himself. So, I don't, him ultimately being the owner to me is real suspect. Even if you don't throw out all those exhibits, which has the deed and has the wills and has the trust, and I moved to strike them because while Mr. Gonzalez had not filed that motion, that memorandum in opposition, he had sent me a copy of it by fax. So I got it, and well, as you pointed out, Judge, no affidavit, nothing to establish these exhibits as authoritative or legitimate. So I filed the motion to strike before the hearing. When Mr. Gonzalez at the hearing started mentioning those exhibits and his arguments based on them, I said, well, Judge, I have filed a motion to strike that memorandum and all the exhibits. And the judge said, well, I don't have the memorandum in front of me, so it hadn't been filed and I can't consider it. So at the end of the hearing, when the judge announced that he was going to grant my motion, I already had an order. He signed it. I already had a summary judgment. He signed it. At that point, he turned to Mr. Gonzalez and says, well, you want to go ahead and file that memorandum that you've got in your hand, and so you can have it on the record? And he said yes. And at that point, I said, well, Judge, I'd just remove my motion to strike because it's just improper. He said, well, I'm ruling without striking. So, we need to be mindful that all that trusts, both trusts, the wills, one of those exhibits was a letter from a CPA. All that is not record evidence. What is record evidence is the complaint in which they allege at the time of the storm we owned it, and what's record evidence are their requests for their responses to the admissions in which they say, no, at the time of the storm we didn't own it. Each piece of property, and they admit that each piece of property was owned by the trust. That's what's the record evidence.
Opposing counsel suggests that there is, in fact, a disputed issue of fact on the record because the answers to interrogatories create one.
Well, the answers to interrogatories weren't filed, so that's wrong. But even if they were filed, they wouldn't create an issue of fact. They're not in the record. They weren't filed. We've talked about the real party and interest rule. Appellant says, oh, real party and interest, I get to file. The purpose of the real party and interest rule is to protect the defendant. It's not to protect the inartfully drafted complaint so that somebody else can bring suit. It's to protect the defendant from being sued, in this case, by somebody in a subsequent suit, by somebody who wasn't a plaintiff in the initial suit. What's to prevent the sister, Mr. Hill's sister, from coming in here and saying, oh, that condo got put to me, given to me. I'm the real party in interest. That's just an example. That's the purpose of the real party and interest rule. It should not be used as it's a shield for the poor defendant. It's not a sword for the plaintiff whose complaint was not properly drafted and who had a year after the depositions in which the ownership issue came out to move to file a motion to amend. There was never any motion to amend filed. There was never any motion to amend made or filed. And of course, since there was never any motion to amend, there wasn't a proposed amended complaint attached to it, setting out the basis. And if the reason that the rule requires the proposed amended complaint to be attached to the motion is so that if the trial judge denies it, you can see, well, was that an abuse of discretion? Here's what the allegations were in the proposed amended complaint. That was not done at any time, not after the depositions, not at the time of the hearing. It's never been done. I don't have anything else unless there are more questions.
All right, thank you, counsel.
According to my review of the record, the answers to interrogatories by Mr. Hill were found in the record reference number 59 and record 59 for Mr. Hill on June 11th of 2007, and Mr. DERANEY was the record referenced at page 62 regarding that.
So the interrogatories were filed?
It is my understanding that that's in the record, yes, Your Honor. Regardless of that, it is our position that...
well, let me just follow up on that.
Certainly.
If they are filed, I'll go look at them. What issue of fact do they create?
Your Honor, it's my position that the issue of fact, and I'll just reference Mr. Hill's because I have it before me, but he clearly states in the answer to number 11, I, R.C. Hill, owner of Penthouse number 6 and president of the Leaky Atrium Condo Association, walked over it. So it presents issues of fact regarding the fact that he was the owner at the time of bringing the lawsuit.
Heck, he said in the complaint he was the owner.
But that's, and I agree. I think the complaint in and of itself creates a dispute of fact. Defense counsel is stating that they weren't the owners. Mr. Hill was clearly the owner at the time of bringing the lawsuit, but he's clearly the beneficiary of a trust. He's clearly the...
How was the trust ever even authenticated? I mean, there's no affidavits, there's no authentication,
Your Honor,
nothing from the sister. We don't know whether this ended up in her trust, his trust.
I'm sure if Mr. Gonzalez had to do it again, he would attach the trust documents to an affidavit or attach them to the depositions or something along those likes. But it is our position that although the defense counsel states that he moved to strike them, the court clearly rules in the last page of the hearing, the court clearly states to Mr. Gonzalez, would you like to file that your motion memorandum and your attachments? Yes, Your Honor. That being the case, Mr. O'Quinn renews his motion to strike.
Is it your position that an exhibit to a memorandum of law is record evidence for purposes of consideration for summary judgment?
I believe it is if the court states that it can receive that, even over objection, I believe that it can be, although the preferred method would be to attach it to an affidavit or a deposition or make it part of a discovery response. In this particular case, the court states, I am ruling without striking. I mean, it seems to me, the whole thing is about, in light of the genuine issues of fact, are two people that do not have legal ownership. You can file all the affidavits you want, but I think that I don't think that changes anything. Clearly, Mr. Hill, at the time of the hearing, and Mr. DERANEY both had legal ownership of the process. Mr. Hill had it prior to bringing the lawsuit. I believe that under the rule of civil procedure 1.210, that they had sufficient standing, and that if the court required them, in terms of amending the pleadings to state the manner in which they are pursuing the claim, then the court, rather than granting a motion for summary judgment and barring the plaintiff's claims by the statute of limitations, the court should have denied the motion for summary judgment and allowed the plaintiff to amend their
Counsel,
complaint.
you've exhausted your time. Thank you so much.
I thank you, Your Honor, and I hope the court shall reverse and remain.
Thanks.